Welcome to the 10th and final episode of Plaintiff Prep. Let's start with a quick recap of everything we've talked about so far. So you suffered a serious injury. You were careful about what you said at the scene of the accident, and you took photos and videos of everything you could. You also gathered contact info from witnesses, you went to see a doctor, and you got the medical treatment that you needed. You kept your accident to yourself, and hopefully you did not post about it on social media. Then you did some research and found an attorney you wanted to talk to. You set up a legal consultation and you talked with the attorney about what happened to you. You decided you wanted to move forward with your claim, so you signed a contingency fee agreement with that attorney. After that, you and your attorney sent a demand package, and the insurance company did not accept your demand for payment. So your attorney filed a lawsuit on your behalf. Then you exchanged discovery with the defendant and you went to mediation. Again, the defendant didn't want to compromise, so the mediation ended in an impasse. Now you're heading to trial. The purpose of this video is to help you understand the trial process so you can know what to expect.
Let's start with jury selection, also known as voir dire. Jury selection occurs at the very beginning of trial, and the purpose is to determine whether potential jurors are prejudiced or biased in a way that would prevent them from being fair or impartial. The attorneys and judge will ask questions, and the jurors will respond. Based on the jurors' responses, they may be challenged for cause. A cause challenge might occur if a juror is related to one of the attorneys or one of the parties to the case, or if the juror indicates that he or she cannot be fair in hearing the case. Each side also gets peremptory challenges, which basically allows each side to remove a limited number of jurors for any reason or for no reason at all.
Now, let's talk about opening statements. Opening statements occur at the beginning of trial. A lawyer from each side will give an opening statement to the jury explaining what the evidence will show. Your attorney will also tell the jury your story or a narrative of what happened. However, neither side may argue facts or law during the opening statement. They can only talk about what the evidence will show.
Now it's time for the plaintiff's attorney, your attorney, to present its case in chief. This is the part of the trial where your attorney will present your exhibits and proffer witnesses' testimony. Your attorney will probably start with witnesses that have the best information regarding liability. This is where it comes in handy to have eyewitnesses, and this is why we ask you to get witness contact information at the scene of the accident, if possible. Your attorney will call each witness to the stand for a direct examination, and then the defense will cross-examine the same witness. After that, your attorney may engage in a redirect examination, and the defense may engage in a re-cross-examination, depending on the jurisdiction. After the liability witnesses have been examined, your attorney will likely present damage witnesses. These are people that can testify regarding your injuries and how much you've suffered as a result of those injuries. After your attorney presents its case, your attorney will tell the judge something along the lines of, "The plaintiff rests, Your Honor." And that will be the end of the plaintiff's case in chief.
The defendant's case in chief works just like the plaintiff's case in chief, except the roles are reversed. The defendant's case in chief will include the defense's exhibits and witnesses, and the defendant will call each of its witnesses for direct examination. After that, the plaintiff's attorney will be permitted to cross-examine each witness.
If the plaintiff's attorney feels that the defendant's case in chief clouded the issues or otherwise hurt your case, the plaintiff's attorney may call rebuttal witnesses to counter the damaging evidence or testimony. In some cases, rebuttal witnesses are necessary. However, many times, a plaintiff's attorney will not call a rebuttal witness.
Let's talk about closing arguments. After both sides have presented all their evidence, they will be permitted to make closing arguments to the jury. Each lawyer will have a limited amount of time to talk to the jury about the evidence, to summarize the case, and to draw conclusions and inferences from the evidence. Each lawyer will try to show the jurors how the evidence supports its case. In closing arguments, the plaintiff's attorney will go first, and then the defense. After the defense gives its closing argument, the plaintiff's attorney is typically allowed to offer a quick rebuttal argument.
Finally, let's talk about the jury verdict. After closing arguments, the jury will receive instructions, known as jury instructions, and then they will retire to the jury room to deliberate. The deliberation could take hours or days, depending on the case. The jury will elect what is known as a foreperson, and the foreperson will be responsible for helping the jurors reach a verdict. If jurors have a question, they will submit the question or questions to the bailiff, and the bailiff will bring the question to the judge to be answered by the judge or the lawyers. Once the jury reaches a verdict, the elected foreperson will fill out a jury verdict form and sign it. Then, the bailiff will notify the judge that the jury reached a verdict. Next, the lawyers and the parties will return, and the bailiff will bring the jury back into the courtroom. After that, the judge will confirm with the foreperson that the jury reached a verdict. The foreperson will hand the verdict form to the bailiff, and the bailiff will give it to the judge. The judge will then read the verdict out loud and on the record.
And that will conclude your trial and this season of Plaintiff Prep. Thank you so much for joining us, and please tune in for more content.